Bonjour à tous.
Good afternoon, everyone. Welcome to this first meeting of the Secu Committee in 2026. On behalf of everyone, I think, let me just wish you a very happy new year, a year of peace, happiness, and good health for one and all here in the room and all those following our proceedings this afternoon. We are now at meeting number 20 of the Standing Committee on Public Safety and National Security. Pursuant to the October 3rd, 2025 Order of Reference of the House, the committee is meeting today as part of its study of Bill C-8, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. Let me now welcome the Minister of Industry and department officials who were kind enough to appear before us today. Madam Minister, you have the floor. Thank you, Chair. Thank you, Jean-Yves. Thank you, dear colleagues. Happy New Year to all of you. I'm here today to talk about Bill C-8, an act respecting cybersecurity. This bill was already adopted by the House of Commons and sent to the Senate in 2024. I'm here in good faith to continue this essential work. This bill is about something that Canadians depend on every day, our telecommunications networks. Our telecommunications networks connect Canadians and support our economy. The growth of the digital economy, is thanks especially to the spread of 5G networks, might add up to $112 billion to the Canadian economy between now and 2035. And so it's a wonderful opportunity, and we have a responsibility to protect it.
Connectivity comes greater exposure. Cyber threats are more sophisticated, more aggressive, and borderless. Canadian businesses lose more than $5 billion every year due to cybersecurity incidents. This is a massive cost to our economy, our competitiveness, and to the jobs Canadians rely on. If we want Canadians to trust these systems, and if we want businesses to continue investing and innovating, our infrastructure must be strong, secure, and resilient. And this is exactly what Bill C-8 does. Bill C-8 modernizes the Telecommunications Act by making security a core objective. It gives the government targeted and practical tools to act when there are serious risks to networks. It requires consultation with affected parties before any order is issued, ensuring transparency and collaboration. At the same time, it is important to be clear about what this bill does not do. It does not allow the government to shut down services for individuals. It does not allow the interception of private communications. Infrastructure security is not freedom of speech. This bill is about protecting networks, not regulating expression or ideas. Bill C-8 includes strong safeguards, and the government is accountable to Parliament. We will ensure that the bill is explicit in affirming Parliament's ongoing oversight of these powers. There is robust parliamentary oversight, and CIRA and SICOP play a vital role in reviewing national security activities, and this legislation fully respects that framework. Les réseaux de télécommunications sont essentiels à la...
Telecommunication networks are essential to the security, prosperity, and well-being of Canadians. Bill C-8 enables the government to protect in a responsible, targeted way these networks with a rigorous oversight. We will continue to work to ensure that Canadians can live in security and be well connected. Thank you, Chair. I'm happy to answer your questions. Thank you, Madam Minister. We can now move on to the first round of speakers, questions, beginning with Member Caputo. Thank you, Chair. Thank you, Minister, for being here.
Minister, this act, I think we can agree, confers tremendous powers on the Minister and the Governor Council. We can agree on that, I take it?
Well, it is, how can I say, it's important responsibility, and that's why there's Parliament oversight.
Okay. Now, parliamentary oversight happens after the fact, as in after a decision is made, then Parliament looks at things. And we know how that sometimes goes, because if the wrong decision is made, then we try to repair it after the fact. So what I'm going to ask you, Minister, is this. why wouldn't we have judicial oversight, as in a judicial authorization at the front end, whenever you or the government wishes to take action, like in 15.2, to ensure the government isn't breaking the law? Would you not support that rather than looking at something after the fact to see if we got it right?
So I hear you, and the goal is definitely to make sure that the government can act, particularly in times of national security where urgency is required, and also that it is part of our intelligence system. But we have already NSICOP and CIRA that are doing that work. And I must say, having dealt with a lot of security issues in my former role, I think that this is an important how can I say that it is an important power given to the Minister of Industry that we don't take lightly.
I understand
but
that.
at the same time,
Minister, I'm sorry, we only have a few
dear
minutes.
colleague, I just would like.
We just,
What is preoccupying to me right now is we passed that bill.
I understand that, but I'm not asking you.
pass
Okay,
this bill in the
sorry.
past.
asking you
Sorry,
about
I have
that,
to stop
Minister.
both of you.
Yeah.
I'm not asking you about
Sorry,
that.
sorry. Donc, je vais dire en français.
Let me just say in French, we can't all be speaking at the same time. Otherwise, it'll be impossible for interpreters to do the work and for everyone to understand what's being said. Please continue.
I'm trying to interrupt you, Minister. I only have 4 minutes, and we've
No,
got
go
a
ahead.
lot to get through. So please do not take it personally if I do interject.
No, I don't.
Here's the thing. Everything you've discussed, though, is after the fact, and you talk about robust oversight with NSICOP. There is a principle in law called exigency, as in when a warrant can't be obtained or judicial authorization can't be obtained. That's different. In some instances, a judge would have the time and the evidence. Warrants are often obtained within a few hours. Why, rather than the minister exercising unfettered discretion over such broad powers, would you not agree that judicial authorization, an independent judge, should be the one making the decision where we can do that?
If the committee comes up with amendments, of course we'll study. So our goal is always to make sure that we get to the right balance, because I think it's really important that indeed that basically the powers of a given minister in given circumstances have guardrails. I think it's important.
I understand that.
But at the same time, this must fit in the Over Telecommunications Act infrastructure, which is also in line with the CRTC, et cetera. So we would need to make sure that it fits, and that's why in the circumstances this was proposed, but maybe, Casey, you want to add anything?
I would like to restrict my questions to you, Minister, with all due respect. We can ask the officials afterwards. I've got 2.5 minutes left with you. Again, I don't understand. This isn't, I don't think I'm being obtuse or anything. Why wouldn't we have an independent judge decide whether there is evidence for you to wield these significant, virtually unprecedented powers? Why wouldn't we give that over to a judge, Minister?
Listen, I don't think unprecedented power, Frank. I'm sorry. I think it's an important bill, and it's about making sure that we can protect our critical infrastructure. But I think also that we had already unanimous consent over it. We have a model right now that is based on a voluntary approach by telecommunication service providers that doesn't hold, because right now we have policy statements on national security that are voluntary. So this would just make sense to give these powers and make sure that the telecommunication companies abide by them. By the way, I must say the Minister of Industry under the Telecommunications Act have great power also regarding how the telecommunication sector is organized.
1 minute left, Minister.
And so I think what is presented to you here is very coherent, in line with what is the policy across the country already.
Why should Canadians trust you with these extraordinary powers given your government's record?
So this is not about personalizing the approach.
I'm talking about the
any of
government,
us
not
could be one
personally.
day Minister of Industry,
Yeah, I'm
it's
talking about
about
the
the
government, though.
responsibility that is given to that individual during the tenure of the government. And our goal is to protect Canadians. And this is our number one responsibility, and that's what we're doing through this.
But even when you sat around the cabinet table, we have seen so many failures with this government, whether it be Stellantis or the Emergencies Act. I don't know that Canadians have the trust when it comes to balancing rights and protecting our infrastructure. That's why I believe in judicial authorization.
Well,
Thank you.
So if I would like just to answer to that, I think Canadians have already given trust in our government, and that's why you're sitting on the right side of the table.
Well, that's a
Thank you.
I think we will stay.
Little inappropriate.
We'll stop here and invite MP Akan for 6 minutes, please.
Thank you, Mr. Chair. Thank you, Minister, for joining us today. So, as we all know, this is our 5th meeting on Bill C-8, and we heard experts on the importance of this bill, and especially some of these experts are the Canadian critical infrastructure leaders. So, throughout the study of this bill, we also heard the Conservative colleagues who claim that C-8 will allow the government to kick Canadians off the internet for just criticizing our government. We know this claim to be false, but can you please reiterate to the committee why claims as such, these are not only inaccurate, but also harmful, equally misinformation that puts Canadians in danger?
Yes, well, so this is not about the content on the internet, about free speech. This has nothing to do with basically what is discussed online. This is about the infrastructure of the telecommunications sector. This is about the towers, the wires. This is basically the mandate of the Minister of Industry, which is about basically protecting Canadians through protecting the critical infrastructure of the telecommunication networks across the country. If I was the Minister of Heritage or the Minister of Justice, conversations would be different, obviously. It would be much more about the content online. It would be much more about either the Broadcasting Act or everything linked to online harms, or potentially the application of the criminal code. But this is not the case. And I hear that colleagues want to make sure that there's certainty regarding that aspect. I'm all willing to hear amendments that would make sense to all, to make sure that we are clear about protecting people's rights online. But I just want to make sure that this very important legislation can pass, because I think that the wisdom of the last Parliament was clear. It needed to be done. It was done. And then because of a technical procedural aspect, this bill had to come back. And now we have to redo the entire work at a time where the world is more dangerous, more complicated, and we just need to have the means to ensure the safety of Canadians through the Telecommunications Act.
Thank you, Minister. So from my perspective, as an engineering perspective, I would say, the resilience of our economy is only as strong as the physical and logical layers of our telecommunication networks. And previous testimony from Bruce Power highlighted that a nuclear facility's security means little if the downstream system of systems, such as the power grid and telecommunication lines, remains vulnerable. How does adding security as a primary policy objective in the Telecommunication Act empower your department to enforce the unified technical baselines necessary to protect these critical interdependencies?
Mm-hmm. Well, as I said, it is not only important because it's overdue, and I mentioned when answering our colleague Frank Caputo's questions that we needed to make sure that we were putting this bill forward because it was a way to ensure the security of Canadians online, and the Telecommunications Act in decades ago didn't put that as a priority, and so we needed to make sure that that was the case. But I think what is important, Seema, to remember is we're the only ones of the Five Eyes that don't have a legislation like this at this point. And time is of the essence. And so that is why I think our allies expect us to do that. This is just good governance to do that. And I think we should not politicize this bill because I don't think this is neither the right content nor forum.
Okay. Minister, in your capacity as Minister of Industry, you met with the biggest industries. Could you tell us what priorities and concerns these key stakeholders have shared regarding the protection of our critical infrastructure from cyber attacks?
Well, I think when it comes to their expectations toward the government is they're expecting us to do our job and to pass this bill. More they're able to have regulatory predictability, the better, because they're able to address the risks and basically the investments required. Right now, we have a voluntary system, and including a policy statement back of 2022 that is important, but that doesn't give any form of really teeth, if I can say, for the government to make sure that it's complied by the telecommunication service providers, and that's an issue. And so I think that more we're able to pass this bill, more it will be factored in by those that are in the telecommunication sector.
Merci, Madame la députée Akan.
Thank you, Madam. I can give the floor to Madame Bellefeuille for 6 minutes. Thank you, Chair. Thank you for appearing with us today, Madam Minister. When you draft a bill, there are upstream consultations to ensure that the bill is in line with the objectives. And I was surprised that the Privacy Commissioner's recommendations were not included in the bill. He said that there was some imbalance in terms of proportionality and what is really necessary in this bill. And we get the sense that we felt that the government was attached to the idea of proportionality and necessity, because for Quebecers and Canadians, protection of privacy is essential. Could you tell us why you didn't include the recommendations of the Privacy Commissioner? Well, I inherited a bill that had already been passed, and for procedural reasons, which were unfortunate, the bill died on the order paper, and so the new bill was tabled. It was the same bill. The legislative parliamentary work had already been done. I understand that colleagues have other opinions now, but I was saying in response to Member Caputo that I'm very open to amendments. So you're open to amendments that might be in line with the recommendations of the Privacy Commissioner? Yes, yes, I am. My goal is to ensure there is regulatory predictability and stability, but also to strike the right balance between government powers and protection of privacy. My second question it has to do with comments from witnesses who said that this bill weakens encryption and actually makes cyber attacks more likely. It makes it easier for agencies to have access to personal information, but also for foreign entities. So my question is, why is there this wish to weaken encryption standards? No, I don't think the goal is to weaken encryption standards. Do you have anything to add on this? I think my colleague Andre is well placed to answer that question. If I may, I'd just like the minister to understand that this is something quite important. I learned this. I didn't even know what encryption standards were, but undermining these standards was something mentioned by a number of witnesses. Perhaps you could explain to me why this is the case. No, my colleague could, I'm sure, has something to say about this. I could also speak to it. Thank you for the question. I understand the concerns, that these concerns exist. But the goal of the bill, the goal of the policy, is to provide greater security to the telecommunication networks. It's already impossible to break encryption. I've asked the question many times. It's as straightforward as you say. Why did so many expert witnesses express their concern about this? And maybe, Madam Minister, you could tell us, why is it that the witnesses who appeared really expressed a serious concern? So when it comes to encryption standards, and we're quite ready to accept amendments on this matter to ensure that there's no clash between telecommunication systems and their infrastructure and the point of transfer to users and the right to protect one's privacy. We understand that there's this transition that has to be covered by the bill. And so I would be delighted to receive amendments on this matter because, quite rightly, I don't want to see any threats to privacy. This is my position. But I'd like us to focus on infrastructural matters. So thank you for being open to amendments. My last question, I just have a minute left, has to do with overlap. Electricity Canada made the following recommendation. They looked at, take the example of Hydro-Quebec, which already has reliability standards that are international reliability standards that are not American and are worried about overlap and duplication. And if this could somehow be clarified, this would please Electricity Canada and make things easier for Hydro-Quebec. The Telecommunications Act is a federal act and under federal jurisdiction, so we're not worried about being outside of our jurisdiction, but we'd be happy to work in cooperation with electricity power companies across the countries who are under provincial jurisdiction. But let me just interrupt you. Is electricity transmission and distribution under federal jurisdiction? Telecommunications are federal, but electrical transmission are not federal. If they're within the province, they're provincial. It's under provincial jurisdiction. Sorry to interrupt, but your time is a very interesting subject. I could give you a whole lesson on shared jurisdictions.
And officials for being here. Minister, one of the key reasons your government cited when bringing forward this legislation was the need for the authority of you as minister to remove hardware or prevent the installation of hardware that could pose a threat to our telecommunication system. Specifically, I'm talking about Huawei and ZTE. Can you confirm to this committee that if granted these powers, you will make an order to remove any remaining Huawei technology from our telecommunications system?
So, well, that's the goal of the 2022 policy statement regarding ZTE and Huawei. And that's why I've been mentioning this is the third
clear
time.
answer, yes or no, Minister?
I just
yes
want to
or no,
finish.
Minister? Will you use this legislation?
I'm sorry, dear colleague.
No. I'm sorry. This was going well. I know it's going to keep going well, but we can't overlap. Otherwise, no one can interpret and no one can understand either. So let's continue in the appropriate manner. MP Lloyd.
Yes or no? Will you use these powers to order the removal of any remaining Huawei technology from our telecommunications system?
So that's the goal of the 2022 policy statement, which was to make sure that there would be none.
Well, the whole reason for this legislation being brought forward, Minister, was to give you the authority. That is what your government stated they needed this for. So we're talking about granting you these powers. You now have these powers when you get this, if you get this legislation passed. Will you use it to remove Huawei and any other threats to our telecommunication system?
Of course, that's
Okay.
the goal.
Now, following your government's recent trip to China and the Prime Minister's efforts to reset the relationship, was there any discussion about reconsidering the ban on Huawei?
No?
Okay, and I'm asking this because your office and the Public Safety Office were asked repeatedly by the Hill Times about these discussions, and they refused to respond to any of those questions. So I think Canadians had a lot of concerns about that. Now, Minister, C8 proposes a number of new powers for you, including the ability to direct a telecommunications service provider to do anything or refrain from doing anything that you deem as a threat to interest in national security. What safeguards are in place to ensure that these are not abused?
Well, I've already answered that question. There's definitely parliamentary oversight by NSIRA and SICOP. I think that was something that was well noted last time when the bill was studied, and that was added. I think it's actually, having gone before in the SICOP in the past and having worked with NSIRA, they can go into the details of many public safety, public security questions that are key. Of course, everybody on this committee have their security briefing. We believe in security briefings being a key part of the work that can be done by parliamentarians, and we'll work with them. That will be at the core of any Minister of Industry's work in the future.
Thank you, Minister. The Privacy Commissioner has testified that this bill is lacking key privacy safeguards, including an inconsistent proportionality test, which is included in Section 15.2. And there's no requirement for his office to be notified by the Canadian security establishment when a major cyber breach threatens Canadians' private information. I find that these omissions in the legislation concerning. Are you supportive of these amendments to alleviate the Privacy Commissioner's concerns?
That was the question of our colleague here from the Bloc Québécois, Claude Bellefeuille, just asked that question, and I'm very sensitive to that question. Because I think it's really, really important that we address the issue of proportionality. And I really, really think that Canadians should know, should there be breaches, of networks containing their data, that they should be informed. So I think that I would be very interested in seeing amendments regarding that.
Now, in my last minute or so, I thought it was very interesting that you stated that an individual will never be cut off from their internet access. That was a very unequivocal statement, which I'm pleased to hear that you said that. Nobody has been very clear that the officials were not that clear in saying you don't anticipate there's any situation where an individual would have their internet access cut off, like if they're a hacker or something like that?
Well, the bill refers to the term person, and the term person was defined as basically companies. And so I think it was just lost in translation, but we can make sure that actually telecommunication service providers and obviously their suppliers could be, we can make sure that we define that in a way that we're not creating any form.
One concern is that, let's say somebody is caught up in this. They might not have like the legal ability to challenge a decision like this. There is judicial overview. If somebody were caught up, what resources are going to be made available to ensure that somebody who feels they've been unfairly targeted by this legislation can challenge this?
Like I said, this legislation is not targeting individuals.
Okay, well,
it is
we want to be clear
targeting
about
companies.
Thank you.
And so but I think it's a fair point, and that's why we'll make sure that we address it. Thank you.
Très bien, merci pour cet échange, député Paul.
Thank you for that exchange, Deputy Parlowski.
I understand the importance of protecting privacy, and I understand the importance of transparency, and so you need to have these checks and balances within the legislation. But in responding to a cybersecurity threat, I think that in particular you need to act very quickly. And I'm thinking nowadays, especially with AI, you put something and you ask some complicated question to your computer and your laptop, and then it goes off into outer space and around, and within almost like a couple of seconds, it comes back with a response that would have taken us days and days to have come to in the old days. So obviously the threat is going to be very fast, and you have to consider that when you're putting in your checks and balances. If I was Mr. Putin, I'd say, put in a lot of checks and balances. We got to be really certain that we don't violate civil liberties here. And so it takes hours or days. And so I know there's a balance. And can you talk about this bill and how the order-making power under this bill provides the flexibility to respond quickly to cyber attacks while still being subject to clear reporting and accountability mechanisms?
Yeah, and I think I hear what the Conservative colleagues are talking about, but we're also inspiring ourselves from legislation that has been adopted within the Five Eyes. And we're also we're looking at what has happened in real life events such as ransomware. I know Nova Scotia Power was victim of one in 2025. There was an AT&T breach also in 2024, which basically that was a breach of user information. I could go on. I have many in front of me right now. In South Korea, SK Telecom reported a cyber incident with malicious actors accessing data. There was also espionage and disruption that happened primarily in the U.S., but that was the Salt Typhoon event in 2024. So I'm just saying that sometimes time is of the essence. We need to be able to inform telecommunication service providers that maybe are not aware. We need to be able sometimes to also ask them to do things very quickly while dealing with an ongoing threat that is affecting many allies within NATO. So that's why I think that we cannot address how can I say, time is of the essence and we need to be efficient. But that's also why we need to create parliamentary oversight, and the NSI COP and NSIRA, how can I say, approach is the right one, because you're able to see whether the government did the right thing at the time based on also the intel that was offered to those who were taking the decision.
2 minutes.
Okay. Mr. Caputo suggested that if there was time, that there should be judicial oversight and a requirement to ask for a warrant beforehand. Do you know, or can some of your staff tell me, because you say all the other Five Eyes countries already have similar legislation, in the legislation from those other countries, is there that kind of judicial oversight? Is there a requirement for a warrant before you act?
Yeah, Andre can answer that question. Yes.
Thank you, Mr. Chair, for the question. In this particular context, where we're talking about authorities to regulate the operation of network infrastructure by the private sector, I'm not aware of any such example that exists. The type of circumstances where there is that type of warrant architecture exist when there's like an investigative function. So there's some type of either intelligence surveillance or other law enforcement type surveillance that's outside of the context of regulating the day-to-day operation of the networks, and it's about having government authorities have access to information that normally would be subject to right to privacy.
So the kind of cybersecurity threat that an outside source is trying to shut down your system, your transmission lines, your power stations, those aren't normally in other countries' legislation subject to that kind of judicial oversight?
No, not that I'm aware of. And the court, certainly the court in Canada, does not currently have the expertise or capacity to consider those types of questions that get into the substantive day-to-day operation of the network infrastructure, as opposed to questions about rights or investigations.
Merci au député Pawlowski. Madame de Bellefeuille.
Thank you, Madame de Bellefeuille, for 2.5 minutes. So I have two questions for you, Madam Minister. Honorable Simon Noël, who's our Information Commissioner, made two recommendations on C8. He suggested that an independent commissioner be nominated to ensure independent oversight to oversee the sharing of personal information. The second recommendation was that any expectation of document seizure or personal information should be done through a warrant issued by a judicial authority. So this commissioner said, here are my recommendations, and yet these concerns are not addressed in the bill at all. Could you explain why the information commissioner was not included? It was not addressed? I gave an answer to your earlier question that we tabled the same bill that had been passed in the House and at the Senate that had unanimous support, in fact, and that was actually the object of all-round consensus. I know that new interpretations have emerged since. We are ready to accept amendments. We are prepared to work with the Personal Information Commissioner to address the matter of protecting Canadians' personal information, but the building a new commissioner's office or infrastructure might not be necessary. We can address this directly. We can address the commissioner's concerns in the bill itself. I'm not too familiar with the exact mandate of that commissioner, but he didn't want to take this into his mandate. He suggested that a new commissioner's office be created. Why? Well, you'd have to ask him that question. But I think it had to do with geopolitical events where there had been cyber attacks on Government of Canada infrastructures against businesses. And when it happens, things move very fast. And that's what worries me. We have to be able to deal quickly with situations that are happening in real time, and we have to ensure that we are protected immediately. And once the initiatives are taken, we're in crisis management situation. Yes, we can see if things were done properly. Sorry to interrupt you, Minister. We have to move on to the next questioner, Deputy Strauss, for 5 minutes.
Thank you, Chair. Thank you, Minister, for being here. So you had said in your opening remarks that this bill would not provide for the withholding of services to individuals. In an answer to my colleague, Mr. Lloyd, you said that even though the word any individual is in the bill, going back to the definitions in the Telecommunications Act, an individual person wouldn't be included. I have with me here the definition section of the Telecommunications Act. It says it defines person as includes any individual. So are you here undertaking to change that definition so that it does not include any individual?
I'm willing to make sure that there's even a section, if you bring in an amendment, and we could definitely work with it, to make sure that it is clear that this will not have any impact on freedom of speech online or anything linked to people's, the type of content that could be put online.
But would you remove the definition?
And so basically making sure that, and that was a bit my answer to my colleague from the Bloc, our colleague from the Bloc Québécois, is I want to make sure that we're talking only about the critical infrastructure, that it doesn't go into basically the connectivity part of ultimately what are we talking, how are we addressing how people are basically discussing on the internet. And I think that's really important because I think it's not the role of the Minister of Industry. This is not how the government is organized. I think it's on the Minister of the Department of Heritage that question should be addressed.
Okay, thank you. Because the bill, as it's written right now, says that you would have oversight to withhold services to any individual if any threat to the telecommunication system arises, and that it doesn't say any physical threat, any structural threat. It says any threat. And what particularly concerns me about that is that there are several internal Government of Canada documents describing misinformation and disinformation as threats to the telecommunication systems of Canada. So I put it to you, do you and your government believe that misinformation and disinformation are threats to the integrity of the telecommunication system in Canada?
But this is not about misinformation, disinformation, and that is a question that should be asked much more in the context of anything linked to online Harms Act or everything that would be much more about content. At industry, we're not addressing these questions. It has nothing to do with it.
Well, I hope not, but the bill is before us as any threat. So are you hereby undertaking to change that language to be any physical or structural threat?
The bill is clear in terms of this is about critical infrastructure and the threats that could be done to basically the telecommunication networks, the wires, the towers, et cetera. It has nothing to do on what is being discussed online. And I think last Parliament saw that clearly, and I think this should be clear here as well.
I think it should be clear.
I understand that if it's not clear enough, we can make sure that there's amendment regarding that.
Okay, fantastic. So in the previous Parliament, when this bill existed as Bill C-26, it was thoroughly criticized by the Canadian Civil Liberties Association, the Canadian Constitution Foundation, the Justice Center for Constitutional Freedoms. I've discussed the bill with the directors of many of those organizations. None of the criticism that they made turned into amendments when that bill was passed by the Parliament. And none of the conservative amendments, as far as I can tell in the archaeology of this bill, were passed at the last committee. So it sounds like you're now expressing an openness to amendments, but none of that occurred when amendments were sought for Bill C-26 in the previous Parliament. Why the change?
Well, listen, I have Doug Shipley, the member for Barrie Springwater, Oro-Medonte, that said, Madam Speaker, I'm proud to rise in this House today to speak to this important legislation on behalf of the good people in my riding. I'm pleased to see Bill C-26 come forward in the House for improving the resiliency of our critical infrastructure is the utmost importance to our national security and the everyday safety of Canadians. That's what your colleague mentioned. There's another
Thank you.
one.
I've never met that colleague. I'm interested in your opinions about
Bill
that.
C-26 is a bill that addresses an important and growing topic. Cybersecurity is very important, very timely. I'm glad that in calling this bill today, the government sees this as a priority. And that was a member from Calgary Rocky Ridge, Alberta.
I'm sorry, that has no bearing on my concern or the concerns of my constituents.
Madame la ministre, on va passer la parole au député Strauss.
Madam Minister, Strauss has the floor.
Accept that the powers in this bill potentially touch on the fundamental freedoms protected in Section 2 of our Charter, the freedoms to expression. If an individual were to find themselves not receiving services from an ISP.
And we have 20 seconds left.
We have a Charter of Rights and Freedom, and every single legislation must abide by it. It's a constitutional responsibility.
Thank you.
And,
do you
and
regret
we're
violating
making sure
Section
that
2
that's
in the Invocation of the Emergencies Act as the Federal Court of
MP
Appeals?
Strauss, I'm sorry to interrupt you, but that's all the time we have. So let me turn to MP Lavoie. Monsieur Lavoie, 5 minutes, s'il vous plaît.
Merci, Monsieur le Président.
Thank you, Chair. Thank you, Minister, for being here with us today. If I may, I'm going to put on my economics hat today. For more than 25 years, I worked with businesses. And for businesses, this is a nightmare. And for a machine to work, we know what to do. We know how to repair it. But for most businesses, it's one of the worst nightmares if something happens around privacy. So the business world needs resources to protect Canada, to protect businesses, to protect investments. This is the way we protect jobs, to protect Canadians' jobs. This is essential. This being said, I'd like to talk to you about predictability. I worked on another committee on trade, and the two words we most heard were predictability and unpredictability. And we know that for all time, businesses have needed predictability to be able to attract investments, and we live in a world of unpredictability if standards keep changing and they have to constantly adapt to new standards. How does this legislative framework provide greater predictability to Canadian businesses so they can ensure they can continue to invest and hire and do so with full confidence? That's a very good question, because there are many things that we cannot control in the world, or what happens at the White House or what happens outside our borders. But there are things we can control, including how we secure our services and our telecommunications networks. And so your question has, in fact, made me think of the cost tied to cybersecurity. I made this comment in my introductory remarks. Every year, cyber incidents, cyber crime, cost us about $5 billion. $5 billion to the Canadian economy, and each cyber incident on average costs businesses $7 million. $7 million is a lot, because we're not just talking about big businesses, we're also talking about SMEs. So our goal is to entrench this predictability that you mentioned. It's unfortunate that the bill was not enacted earlier. It's really urgent that we act. We're quite a bit behind our friends and allies within Five Eyes, and so we have to act. And you talked about investment, you talked about billions in our economy. Can we expect that there will be a strengthening of this protection? This will create new jobs, new specialized jobs in tech sectors and digital sectors? Yes, of course. There are a number of things, in fact. We believe that we can grow jobs in the telecommunications sectors, but also more generally in the digital sector. The Prime Minister often talks about AI. There are many people who works in the telecommunications sectors and in digital services who will also be very useful for building an AI industry in the country. We've seen how the big actors such as Bell and TELUS have invested a lot in AI, and agreements have been concluded with a big Canadian business called Cohere, and we're going to continue to work in that direction. And so I think there's huge potential, but at the same time, we need a regulated infrastructure that expands. And this is really essential. And let me just add to the point you made earlier. You talked about $5 billion of losses to businesses. This number, $5 billion, but for a business, there's been a huge impact on supply chain, on customers. And so I think people are looking forward to this. Thank you. Thank you, Mr. Lavoie. Madam Kirkland, for 5 minutes.
Thank you, Chair. Thank you, Minister, for being here. I'm pleased to hear some of the things that I'm hearing today. It sounds like you're open to recommendations from the Privacy Commissioner, and I think it sounds like you can understand why leaving the standard of what's necessary and proportionate out would create uncertainty about how these powers will be applied. You mentioned that you left. I'm saddened to hear that you left them out because you said you inherited the bill, so it's almost like you just sort of rubber stamped it without looking at what that would have meant. I would have liked to see that not have to be part of the amendment process, but we certainly are happy to hear that you are open and that your government is open to those amendments. At October 30th meeting, the Centre for International Governance Innovation raised concerns about subsection 15.1 and 15.2 of the Telecommunications Act, which give the governor in council or the minister abroad authority to impose secrecy around certain orders and decrees. They recommended that clear guidelines be included to govern the use of these extraordinary non-disclosure powers. So can I ask why the government chose not to include that guiding criteria in the legislation to limit how these secrecy powers can be used?
So I think it's important for people to remember that since we're living in a much more chaotic and dangerous world, the government has to deal with a lot of hostile actors that can sometimes go after a critical infrastructure, including the state one. And so we indeed deal with intelligence services information. And while the Minister of Industry and the Department of Industry is not in charge of that, it will work with other departments, including the public safety agencies and Global Affairs Canada and Defense, to make sure that we can help them addressing the threats. So we have an entire, policy infrastructure when it comes to national security. And we've been able to put guardrails regarding that the way we address sensitive information, particularly when we're dealing with a hybrid warfare, particularly when it comes to Ukraine. And what we did was to develop NSIRA and NSICOP. And that's why I think in the first part of the bill years ago when it was first presented, it wasn't there, and there was great work that was done by parliamentarians to make sure that it would be there. Now I think that the parliamentary oversight has been added, and that's why I'm confident that we can deal with things in a way that is consistent with protecting the interests of Canadians. Now,
So again, I
hear
only
you
have
regarding
limited
the criteria
time,
of proportionality,
Minister.
because I think that's something also we
Yeah,
could revisit.
exactly. We've been past that. We're past that for sure. The Privacy Commissioner warned that the minimum privacy requirements in Bill C-8 are insufficient to govern the sharing of information with foreign governments, particularly where sensitive or personal data may be involved. So given those concerns, what specific limits does Bill C-8 place on the sharing of Canadians' information with foreign governments or entities? And I ask that with the backdrop of during the election, the Prime Minister publicly stated that China is the biggest security threat to Canada. You, in March of 2023, accused China of trying to sow division in many democracies. I lived in China for a couple of years. I've experienced what that can look like. Does the government still stand by that assessment today? And if so, how does Bill C-8 ensure that sensitive information collected under this legislation cannot be shared directly or indirectly with hostile states or bad actors?
Microphone, Madame la Ministre. Votre microphone.
Your mic, please, Madam Minister.
I think we can't look at this Bill C-8 in silo. We have to look at it with all the other legislation that is linked to public safety and national security and all the agreements we have with states around the world.
Okay,
and so we only have agreements on intelligence with our allies, and that's how the government of Canada operates and protects Canada's interests in a very complicated geopolitical world.
Sometimes it seems like we're talking out of both sides. In 1 minute we're allies with China, and the next minute we're not. So excuse my question. Mm-hmm. The Liberal government assured Canadians that invoking the Emergencies Act complied with the Canadian Charter of Rights and Freedoms. The courts have since ruled twice that the government violated the Charter and failed to meet the legal threshold. Do you regret voting for and enacting the Emergencies Act?
10 seconds, and then we have to turn to...
Yes or no?
I think this is a question also that is before the courts and
yes or no? Do you regret it?
Okay, I'm sorry. This is all the time we have.
Thank you.
So we will now move to the député Ramsey for 5 minutes, s'il vous plaît.
Merci beaucoup. Thank you, Minister. We appreciate you appearing before us today. Industry players who appeared before the committee said they were afraid that they might have major investments to make, and they suggested an amendment that might allow for discretionary compensation. We know that the word discretionary doesn't mean much, but I would be happy to know that the Department of Industry is open to the idea of providing some sort of financial support to back up this act. I know there are a range of programs. Is this something the department might be willing to consider if indeed major investments are required? I would say that most investments necessary in the circumstances will have to come from the telecommunications companies themselves, and it's in their interest to make those investments. For the government, our role is to explain what's necessary to protect our fellow citizens, and that's why we want to move forward. That's why we tabled this bill. But at the same time, I think that industry players have to make the necessary investments. They don't want to compromise the security of their own operations or the security of their customers' data or the different stakeholders they work with. I think that we're living in a world that is increasingly digital. We're living in a world in which security can't be taken for granted, and so in such circumstances, I expect that that business shoulders its responsibility, and so the cost of making the investments, it's part of the cost of doing business. That's the cost of doing business in telecommunications. On the question of harmonizations, you talked about this earlier. We understand it with provinces and other bodies and internationally. There are all sorts of standards that apply. We understand that this isn't all going to be in the Act. This will come at the stage of drafting regulations. But I'd just like to have your view that you will do everything in your powers to reduce red tape and useless paperwork, and to coordinate this with the provinces and our international partners. Yes, this is a constant source of frustration, is it not? I know all about it. And our industry team is aware of this. And yes, there is too much paperwork, and much more should be done to reduce red tape. This is a real problem. I also feel that we have to pick up the pace, because there's the American economic threat. It's a real threat, whether it has to do with here protecting the telecommunication sector or in other economic fields, steel, aluminum, the automotive sector, all the impacted sectors. I think these decisions have to be taken more quickly. Last question. You said that all the other Five Eyes countries, New Zealand, Britain, Australia, United States, have already enacted similar legislation. That's reassuring. So probably Canada also needs such legislation in light of the acts enacted in the other countries. Are you confident that our bill, our proposed act, will fulfill its objectives and will be, in fact, better than those enacted in our allies' countries? Yes, it's so necessary. We're really running behind here. This was a bill tabled in we were working with the 2022 declaration. It's really just a voluntary arrangement with the telecommunication providers. We have to move beyond that. We have to place the security of Canadians and of the telecommunication network. We have to make that a priority. The debate is, of course, important, but frankly, we have to adopt this bill as quickly as possible. I think there's a feeling of urgency that should be shared around this table, and this feeling of urgency, I feel it, that's for sure, and I hope everyone else around the table does as well. Thank you, Minister. Last questions from Madame de Bellefeuille. We're really delighted to hear that you will do everything in your power to ensure that there is no duplication and overlapping, impinging on provincial jurisdictions. I'd like to hear you say this. That would really reassure me. When it comes to regulations, that's one thing. But when we're talking about a bill, it has to appear in black and white in the bill. That's much more reassuring. Let me give you a concrete example. When there was a huge cyber incident that affected the healthcare system in Newfoundland at the time, and that really affected telecommunications and data at the time the government could have worked in, how should I put it, in much closer collaboration with the telecommunications companies. There was federal, provincial cooperation, and we even transferred some funds to come to the assistance of Newfoundland to find a solution, or in the Northwest Territories, where there was a cyber incident there as well. When a cybersecurity incident occurs in a provincial government, affecting a provincial government or a business, the Department of Industry is not the only actor to intervene there. The security agencies, we're going to collaborate with local government. We will adapt to the situation as it presents itself. There's a question of fines. Could there be fines? There's some confusion about businesses and agencies being fined. Just to wrap up, perhaps you could, you said earlier that big telecommunication providers actually have a responsibility to do what they have to face up to cyber threats. But as you know, there are small distributors, small internet service providers. There are co-op internet service providers, and often who work in rural areas that are of no interest to the big players like Bell Canada and others. And so we're a bit worried about whether they'll have the resources to implement these new requirements, to satisfy these new requirements. Just a few seconds to answer. Yes, quite. When it comes to respecting jurisdictions, I always seek to respect federal, provincial jurisdictions. We've used all the available time. Thank you very much, Madam Minister. Thank you not only for having prepared your appearance, but for appearing with us today. We'll just suspend the session for a few minutes to let the minister leave and for officials. Proceedings. Before giving the floor to members, let me just introduce who's with us here today. We have André Arbour, who's the Director General of the Telecommunications and Internet Policy Branch of the Department of Industry, and Wen Quan, Director General of the Department's Spectrum and Telecommunications Sector. We have a quorum. Let's start remarks beginning with Mr. Lloyd for 5 minutes.
Back here today, and my first question is, can you confirm, does the government currently have the technical authority to force telecom providers to remove hardware, for example, Huawei hardware, from its telecommunication systems at this time?
Thank you, Mr. Chair, for the question. No, they do not. The policy currently in place is a voluntary policy, and the policy further stipulates the government's intent to introduce legislation to implement it, and that led to the tabling of C-26 and now C-8.
So confirming that C-8 would give government the legislative authority that it currently lacks to order telecoms to remove or to prevent the installation in the future of hardware that, could threaten our telecommunication system.
Thank you, Mr. Chair, for the question. Yes, that's correct. The legislation is just a framework. Like, it is not specific to any one country. It's agnostic to the types of threats that threaten the underlying infrastructure. But yes, it would give the authority to manage supply chain risks, including high-risk vendor equipment.
Do you understand, remember the context in which C-26 was first brought in? Do you acknowledge that the context of this legislation was to give the government the legislative authority to remove Huawei specifically from the telecommunication system?
Thank you, Mr. Chair, for the question. So that was a substantial factor. but it was far from the only one.
No, I agree. It wasn't the only factor. Now, as far as you know, is it still the government's objective to order the removal of any remaining Huawei infrastructure from the telecommunication systems if it does remain after this legislation is brought into force?
Thank you, Mr. Chair, for the question. So the 2022 policy still stands. There's been absolutely no change to that. The tedious bureaucratic addition to that is that ultimately any legal removal via an order in council, via the governor and council, can only be considered after royal assent. And also the provisions of the law in question require consultation, and the government's been consistent, including in its 22 policy, that it will consult before finalizing any rules.
Now, given the government's recent trip to China, the Prime Minister's recent trip to China, and the reset of relationships, are you aware of any, you've said that there's currently no change from the 2022 policy. Are there any proposed changes in relation to hardware, China's hardware and our telecommunication systems coming out of the recent meetings in Beijing?
Thank you, Mr. Chair, for the question. I'm not aware of any changes to the government's 2022 policy. And any rules, should C8 receive royal assent, will be subject to consultation.
Thank you for that. In reference to the bill's previous iteration, the Intelligence Commissioner, who we had a committee, I think he was actually sitting beside you at the time, testified that he thinks that there's a glaring absentee in this bill and that it's the Canadian public. The information that is collected is Canadians' personal information. And he went on to say that in every case that he's seen as the Intelligence Commissioner, a warrant is needed, and you can obtain it from a justice of the peace, you can obtain it from a federal court, and you can obtain it from a quasi-judicial officer. In the present bill, there doesn't seem to be a requirement for such a warrant. Why is that not in C8?
Thank you, Mr. Chair, for the question. So the scoping of C8 is about, colloquially, but this is how it's actually drafted, is regarding the regulation of the underlying telecommunications systems. So information collected from the private sector can only be collected if it's relevant to protecting those systems. Someone's personal information is not germane to that activity.
But the Intelligence Commissioner said that in every case that he'd seen, personal information was included in all of the reports that crossed his desk.
So if there's been a cyber breach and information has been accessed, for instance, that may be one circumstance where personal information is involved. But if I want to establish a rule that requires a regular installation of software patches and underlying network infrastructure, I don't need anyone's personal information, and I don't.
So you said it's not germane. So are you saying that people's personal information would not be included in C8? That there wouldn't be situations where people's personal information would be shared under C8?
We have not been able to contemplate a scenario. We have not been able to think of a scenario where that was necessary. And the powers in C8 are modeled off of existing powers for non-security reasons in the Telecom Act, in the Radiocom Act. There are similar authorities in the Insurance Companies Act and in nuclear safety. They're scoped by the fact that what's relevant is regulating the ongoing conduct of these network industries, and someone's personal information doesn't have bearing on that. The network infrastructure doesn't care about the content of the information. It's all zeros and ones.
But these threats to the cybersecurity system, we're not talking, maybe we're talking about natural disaster threats, but the threats that I think we're talking about, there's people behind those threats. Wouldn't there be a context where, wouldn't there be context provided that so-and-so or so-and-so entity that contains these people is planning to do something that could threaten the integrity of the telecommunication systems? Would that not be a scenario where personal information could be included?
A very short answer, please. Well, may be able to come back to that.
So the information can only be collected when it's relevant to an order-making authority. That's about the management of the underlying infrastructure. So that is the circumstance already scoped by which that can be done. Not for law enforcement or criminal investigations.
Thank you. MP Akan for 6 minutes, please.
Thank you, Mr. Chair. It has been repeatedly noted in this committee's studies that Canada is currently the only G7 country without mandatory cyber incident reporting or a legislation explicitly protecting critical infrastructure. Could you explain how C8 will address this gap, ensure our vital systems are secure, and align Canada's regulatory posture with Five Eyes partners like the US or Australia, particularly with respect to the speed of response when threat actors are already prepositioned?
Thank you, Mr. Chair, for the question. Certainly. So, Part 1 of the bill concerns amendments to the Telecommunications Act. That is a longstanding piece of legislation, but would ensure that there is a new policy objective that gives explicit authority to regulate in advance of the security of the telecommunications system, along with associated authorities to issue rules, to collect information, and to ensure compliance. This allows the government to take action to ensure that companies have the appropriate security and response plans in place so that they are preventing threats and responding to them, that they are installing vital systems to ensure that their networks are as reliable as practical under the circumstance, and for the government to collect information on the threats to those infrastructure as a mechanism of continuous improvement to issue the new sets of rules. But they're limited to the management of the infrastructure itself. There is Part 2, led by the Minister of Public Safety, has a set of baseline cybersecurity protections across federally regulated sectors, and that's to ensure a level of consistency given the interdependent nature of cybersecurity threats that affect different aspects of critical infrastructure.
Thank you very much. So I'll get into the national security portion and the economical threats on our industries a little bit more in depth. So we heard concerns about the financial burden of rip and replace orders for high-risk equipment. However, the Public Safety Canada has indicated that a single data breach cost a Canadian business, as the minister confirmed, that nearly $7 million on average, with the total economic impact of cyber incidents reaching to $5 billion annually. So in your view, how does Bill C8 provide a necessary framework for long-term economic stability for preventing the catastrophic loss of productivity and reputational damage associated with the critical infrastructure failure? And could you please also explain the implications on the industry and how this would also damage our economy and our national security?
Thank you, Mr. Chair, for the question. Certainly, the damage from cyber incidents is substantial, as the minister outlined, and dwarf the extent of costs in terms of protection up front. So it's a cliche, but an ounce of protection is worth a pound of cure. It's much better to be having protections built in as part of your ongoing business activities. So when you buy that next generation of equipment, we're on 5G now, but 6G is going to be the next type of thing, that you have security principles built into your procurement and your planning upfront. And certainly when we contemplate rules under our current authorities, for example, for spectrum management planning, when we are thinking about spectrum auctions or that type of thing, we design the rules with the life cycle considerations for industry to minimize the impact of that industry, and so that they can build that planning into their normal procurement cycles.
Thank you very much. As you mentioned, 5G and 6G technologies. So experts have also noted that the legacy mobile networks were often insecure by design. As we transition to 5G and 6G infrastructure, which rely heavily on software-defined networking, the attack surface for state-aligned actors increases. So can you elaborate on how the new order-making powers will allow the government to proactively mandate vulnerability assessments and secure by design principles rather than relying on the private sector to bolt on security after the breach has already occurred?
Thank you, Mr. Chair, for the question. The department has an ongoing dialogue with industry, but it's purely on a voluntary basis at this time in terms of trying to socialize and encourage best practices. I think with the authorities enabled by C8, first, it allows for clearer information on the nature of those threats to allow for prioritization of actions. It also moves beyond the pure voluntary in terms of being able to establish rules, both in terms of the procurement of like what equipment or services are going into the network, cybersecurity and response plans. So the first objective is to prevent an incident, but the reality is that you're going to have one. Like that's unavoidable. You're going to have a hurricane or you're going to have a cyber attack, like those exist. And so a core aspect of resilience is having response mechanisms so that when there is an incident, you can address it and manage it and secure the network as quickly as possible after the fact.
Merci beaucoup, Madame la députée Akan.
Thank you, Madame Akan and Madame de Bellefeuille, for 6 minutes. Thank you, Chair. I'd like to turn back to the whole question of the harmonization of reliability standards, because this really worries me. Electricity Canada really stressed this, that in the bill you can include something that says that if you member and you are in line with the NERT standard, that this North American reliability standard is very stringent. There are practices that have been developed over time, and C8 is getting mixed up in this, even though these actors have very high reliability standards. Why get involved in this? If you're a member and you uphold NERC standards, international standards, can you just say that you're deemed to also uphold C8 standards? Thank you for the question. Questions about the regulation of the electricity system is a competency of my colleagues in the Department of the Natural Resources rather than in our department. But I know that they're very accustomed to dealing with questions of harmonization to avoid a clash or duplication or overlap. And so it wouldn't be inconsistent, and maybe it would be suitable to include a provision in the bill that says very clearly that those who uphold those standards, Hydro-Quebec and other actors in Canada are also members of NERC. This is a question that concerns me. Provinces have to deal with the federal apparatus. It often takes a lot of time. It's not always very harmonious. And it would be good to include this in the bill because the goal of the minister is to provide robust protection. If such protection already exists, why not state this clearly? That's my line of questioning. My other question has to do with the storage of personal data. There were some witnesses who said that this isn't actually regulated. What information you're allowed to keep, for how long? Do you believe that those fears are justified? Could the bill be strengthened to take up this question of better protecting personal information? Thank you, Chair, for the question. With respect Part 1 and the Telecommunications Act, personal information is outside the ambit or the orbit of our work around regulating telecommunications networks. I have no concerns personally with respect to the management of this personal information because the information that's important to us is the type of equipment, the towers, the battery systems, the backup systems if there's a network breakdown. Personal information as such is not relevant. It's interesting that you say this. I'm sorry to, I'm not saying I doubt your word, but so many witnesses talked about a breach of personal information and how this isn't properly regulated. It's as if these witnesses hadn't understood what C8 was about. But I think that they probably do. They talk about the protection of personal information. That's what strikes me in your answer, that this isn't even part of the bill. And why do these expert witnesses express these concerns then? Thank you, Chair, for the question. There are some questions in Part 2 around incident reports where the possibility exists of transmitting certain types of personal information by coincidence, as it were. That currently exists with virtual reports, not virtual reports, voluntary reports. But there are systems to manage such situations on the Privacy Act, and also the Center for Security of Personal Information. These systems exist already. And Part 2 includes including mandatory reporting in Part 2 does not change these systems, which already exist. Okay, thank you. Your time is up. We'll return to you later. Member Caputo for 5 minutes.
Merci, Monsieur le Président.
Thank you, Chair.
Monsieur Arbieu, I want to pick up on something that was mentioned. I believe it was one of my Liberal colleagues, and they asked you earlier whether a warrant, or I believe they asked the Minister whether a warrant is commonplace in any other of our Five Eyes jurisdictions. And you commented, a warrant is typically used in criminal law based on evidence that's been gathered by the police. Now, I want to reorient, though, how we're looking at this. A warrant is a type of judicial authorization, and a judicial authorization permits the government or the state, if you will, to take certain action. Where somebody has an expectation of privacy, that's where you get a warrant in criminal law, for instance. So, bearing that in mind, that a judicial authorization, whatever you want to call it, some sort of judicial order, would this legislation be precluded by not talking about exigency in terms of exigent circumstances, but where there is a threat and the government is going to act under Section 15, could this legislation not be amended to give the federal court the ability to authorize, based on oath or information, which is how an authorization works, to get some sort of judicial authorization, so it's not the minister making the call, it's the court making the call. Am I being clear on this? Okay.
Thank you, Mr. Chair, for the question. So certainly what the committee chooses to do with amendments is the committee's prerogative. I think there are two considerations that I would flag from just to provide information to the committee.
Please do.
The first one has to do with more a substantive set of considerations, and the second is more procedural. In terms of a substantive basis, and I speak from this having been involved in the regulation of the telecommunications system infrastructures providers for quite some time. The activities that go into that regulatory activity are very different from the activities that courts contemplate, and it is quite rare in a regulatory context to have a non-expert court having oversight in that context. So in terms of when we're establishing rules for how, these have the force of law. These are not something that that can be done just willy-nilly. They have to be something that do care.
Can I stop you there, please? I mean, the point I'm trying to make is that if the government is going to take action, what does the government have to say? There is a threat, right? And this is a threat, and right now it says any threat, and compel any actor to potentially take any action. So I don't know that you need expertise. I mean, with all due respect to the minister, I'm sure the minister isn't an expert on all of these areas. They rely on the bureaucracy to advise, right? So in that case, could you not have something procedurally that says a government official must, on oath or affirmation, detail the nature of the threat and detail the action to be taken and how it fits within the act? Could a federal court judge not look at that and say, yes, you have met the requirements of the legislation without being an expert, because it's clearly let out in legislation what that is? The person is swearing it's true, in fact.
Thank you, Mr. Chair, for the question. So there are additional criteria as drafted, for example, that an order taken must be reasonable in relation to the gravity of the threat, and those types of things.
I know that. Yes.
So just to be clear, this still would be quite a new activity for any court that was trying to consider this. The other, maybe just to add and I've seen when some of these questions come up that are completely new and unrelated to any type of established process. It's quite a lengthy and involved set of considerations. The second aspect from a procedural standpoint is that this would be ultimately a question for the chair if should an amendment come forward, but there may be questions about scope and whether a royal recommendation would be needed. Under C26, we had it was a quite different subject matter, but an amendment from the NDP member that had to do with the provision of special counsel.
Sorry, I will have to interrupt abruptly and rudely, because we now need to turn to MP Polowski for 5 minutes.
So this law protects critical infrastructure, power grids, nuclear reactors, transportation system, pipelines, finance. We have concerns about cyber attacks from China. We've heard about Huawei. Obviously, Russia is of concern. We are part of the Five Eyes. How much is this act and cybersecurity blind to the country of origin of a cyber attack? Could one of the members of the Five Eyes attack Canada, and would this legislation also guard us from that possibility?
Thank you, Mr. Chair, for the question. The bill is country and threat agnostic in terms of the source, and cyber attacks can come from many different places, including from organized crime or that are not affiliated with a government entity. Ransomware is an increasing tendency that we are seeing, enabled by cryptocurrency, that makes it much more profitable to engage in those types of attacks, and we see organized crime involved in those activities.
We're part of the Five Eyes. Is our cybersecurity so integrated with those other countries that we couldn't detect an attack from within those countries? Because I would think, like, given we're Five Eyes, we're all kind of interconnected in the cybersecurity from one of those countries, not a bad actor in those countries. But say one of the governments in these countries decided they may want to attack some part of our economy.
Thank you, Mr. Chair, for the question. would start by saying, because I don't want to overstate the capabilities of my colleagues at CSE, but first and foremost, in terms of my mandate, it's related to the Telecommunications Act and working with my colleagues on securing with the private sector their underlying infrastructure. But I do know that CSE, as part of its ongoing activities unrelated to this bill, have very impressive capabilities in terms of identifying possible threats. And then one benefit of the bill before us is the incident reporting, which allows for better visibility in terms of what threats are interfacing with different vulnerabilities.
Okay, well, here's a very broad question. What are you hearing from the business community? Is this something that protects and furthers their economic interests, or is it something that undermines their economic interests?
Thank you, Mr. Chair, for the question. So I speak to my colleagues in different telecommunications companies on a very regular basis. Anytime any government says, I've got some new regulatory obligations for you, they don't necessarily jump up and down and say, oh great, that's amazing. At the same time, there is, and there's some understandable caution to make sure, like, let's not go overboard here, and let's make sure that what you have in mind is realistic and practical, and that's perfectly understandable. At the same time, they recognize that this is absolutely necessary, that this has to, these types of things are kind of inescapable in any type of modern economy, and what they've seen in our peer nations. They also recognize that there is some real advantages to predictability. So when something is just voluntary and just a suggestion, it can add a degree of vagueness that makes it harder to justify decisions to one's corporate board, and you're kind of in a bit of a gray area. Whereas if something is like clear in terms of regulation, then they're like, okay, we know what our responsibilities are and we know what we have to do.
Merci beaucoup. 2 minutes.
Thank you very much. 2.5 minutes for you, Madame de Bellefoy. Thank you, Chair. With the minister, we heard her say that businesses are responsible for ensuring their infrastructures are sufficiently robust to resist cyber attacks. That's, and she's talking about big players. But what about small providers, co-ops? Coop Césure, Targo. These are very small companies that serve rural areas that have been abandoned by the big players. What have you prepared for these small providers? What will the cost be for them to comply with C8? This really is a source of worry for me because there are a lot of small internet service providers. Have you calculated the cost for them? Thank you, Chair, for the question. Right now, the bill is a mechanism to ensure that rules can be implemented, and in Part 1 of the bill, there is no specific requirement, no specific obligation. There are powers to allow for the implementation of rules. But from our vantage point at the department, we are very accustomed to working with small players with a large number of requirements around spectrum management, for example. And given the level of consultation, we are able to strike a balance between around certain obligations. And this will be at the regulatory stage? Yes. In this type of context, it's really dotting the I's and crossing the T's. If a requirement exists, that are important to the given player, and it's a matter of a small company, the rules are less detailed or don't exist at all because it's not so important for small providers with only a few hundred customers, and that's the kind of context we're talking about. Or the requirements are simpler, in line with the capacity of these small players who don't have a government relations office and such like. Final question. I'm curious. Does the Intelligence Commissioner approve or not approve the initiatives, these information center? This requirement to create a new commissioner, would this add a greater burden to C8? Because the minister said that it was a matter of acting quickly. This was a recommendation from the intelligence community to add a new office, a new commissioner even. In Part 1 of the bill and the Telecommunications Act, the CSE, the Communications Security Establishment, plays no role in the application of these powers. It's a question of requirements for the private sector when it comes to the management of their own infrastructure. Unfortunately, I have to interrupt you. We've already gone slightly over time. So now I'll give the floor to Madam Kirkland for 5 minutes.
I appreciate that you're here now. I have some questions that maybe even repeated slightly from questions I asked the minister, to hear the department's perspective on that. On October 30th, we heard a lot of testimony from different departments, including the Centre for International Governance Innovation, raising concerns about 15.1 and 15.2, giving the governor and council and the minister broad authority. And it's quite broad to impose secrecy around certain orders and decrees. So they recommended that clear guidelines be included to govern the use of these extraordinary non-disclosure powers. So from your perspective, can you give any insight into why the government chose not to include guiding criteria? Is there a reason not to include that guiding criteria in terms of, safety? And, shouldn't we limit when and how the secrecy powers can be used? I'd be interested in your perspective.
Thank you, Mr. Chair, for the question. So I'll start with just underscoring the minister's response in terms of absolutely there is openness to consider amendments, including along the lines of the CG recommendation for criteria there. In terms of the history, in terms of how we got to where we are today, the existing provisions, first of all, it's not practical to have confidential orders on telecom operators, of which there are hundreds, as a matter of course. So there's already a fair bit of we have no choice but to work in open consultation with many partners, and so open by default. And then there were protections that were added in the context of C26 to add some guardrails on the use of these authorities. The first was a requirement that if a confidential order is being made, of a notification to NSIRA and NSICOP so that they can validate that the power is being used appropriately. And then secondly, more detailed requirements in terms of an annual report to Parliament. And so we are required to report on our activities, including on the making of confidential orders. We can't get into the level of detail of what was in the order, but we have to describe at a high level what was done and why.
Okay, thank you. In that same meeting, the Privacy Commissioner acknowledged improvements. I mean, Bill C8, there are some marked improvements Bill C-8 in respect to its predecessor, Bill C-26. Several ongoing privacy concerns, though, include lower thresholds for the exercise of certain powers that may have privacy implications, lack of mechanisms to ensure the Office of the Privacy Commissioner is informed of material cybersecurity breaches that impact. So, do you have any insight into why the bill does not provide a formal mechanism to notify the Office of the Privacy Commissioner when a cyber incident involves protected information?
Thank you, Mr. Chair, for the question. Maybe I'll start with part one and then briefly on part two. So in terms of the authorities around the information collection, and I know there was some question about what explains the different wording in 15.4 versus 15.1 and 2. First, the Information Collection Authority are already within the encadrement, the scope of, can only be exercised if pursuant to 15.1 and .2. So you can only engage in an order-making activity if it's reasonably necessary to do so. We can only collect information if it's related to an order-making authority. So
correct me if I'm wrong, but that's not checked until after the fact.
So those are the criteria that are in the Act already, or the bill already, in terms of scoping our ability to use the authority up front. So it's an ex ante consideration. There are other protections around that, the use of that authority. For instance, the reasonableness criteria is like, it's an established threshold that's used in
Is that my time limit?
law. And proportionality is an aspect of reasonableness there. To your question about CSE notification, this gets more into part two and my colleagues from public safety, but it's not obvious to CSE when a privacy breach has happened, when they receive an incident report. They get an incident report that includes some technical information, whether there's privacy implications. There are already reporting requirements, though, under PIPEDA, and so the private sector still has to report to the Privacy Commissioner under PIPEDA.
Thank you very much for that. Monsieur le député Lavoie pour 5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. Thank you for our witnesses here today. I'm very happy you're here with us today. I have a kind of subsidiary question. My colleague talked about small players in the telecommunications sector. We often talk about the big players, Bell, TELUS, and so on. How do you define, when we say small provider, what does that mean for you? Thank you for the question. There's a huge variety when it comes to players in this sector. There's a small supplier in northern Manitoba. It's a real mom and pop operation, as it were, with just a few hundred customers. But there are some others who have a kind of medium-sized operation with a few thousand or 1 million customers, such as Cogeco or Explore. So when is a supplier no longer considered a small supplier? Is there a number of customers as such? There are no specific criteria in this context. It depends on the context, and it depends on the market one is dealing with. In the drafting of rules, in each context, the consultations are undertaken to identify which size category is the most suitable to manage impact on the private sector. There are some contexts where the rules are simple and necessary, and application is across the board. But in other contexts, it's not worthwhile. or there are considerations as to the impact on small players. And so in such circumstances, we do take into consideration the specific context. So what I've understood is that you still have to you have to draft rules to determine the size, and there are other factors such as geography. What I'm also interested in is the impact on small business. We often talk about big players when we talk about telecommunications. And in Quebec, 72% of businesses have 10 employees or fewer. So just to be efficient, what I want to know is what the impact of this will be on private small businesses to comply with the rules. And this is where problems can arise. You talked about powers between obligations and what's optional and what's obligatory. Small businesses are the majority of SMEs, and they don't necessarily have the staff or the funding or the financial resources. Will you provide support, assistance? So this is really for SMEs, small businesses, which are, after all, the large majority of businesses in Canada. Thank you, Chair, for the question. First of all, there are good incentives for government to support SMEs because that stimulates competition with the bigger players. And so there are a range of mechanisms to support these small businesses. There's consideration when it comes to what rules should be enforced and how strictly. And application of these rules also often only takes place in relation to the big players. There are mechanisms that provide for resource supports, and they can discuss the enforcement of rules with us. There are measures such as information requirements, which are more straightforward, more streamlined with those who have a small number of customers, as opposed to, for example, Bell or TELUS. Thank you very much, Deputy Gill, for 5 minutes.
Well, thank you very much for being here today. And I just want to start off by saying thank you. And then I will be asking a couple questions that might be repeat from before, but these are concerns my community members and myself have, and I want to make sure that I can get the best response I can. So please, I appreciate if you could answer to the best of your ability. For my first question, can the officials please tell us whether the department has assessed the extent of which major providers or the contractors are outsourcing network-related telecom outside of Canada? And what analysis has been conducted on the economic and employment impacts of this outsourcing, as well as its implications for the overall security objectives of Bill C-8?
Thank you, Mr. Chair, for the question. I'll start. My colleague Wen may supplement. First, telecommunications equipment and services is a global market. So when we're talking about the equipment that's used in their network and supporting services, there's a relatively small number of global players. They may have substantial investments in R&D within Canada, but if we're talking about Ericsson or Samsung or Nokia or those types of places, like, we are dealing with a global supply chain with global standards, and we operate in a global market rather than having a purely Canadian context. In terms of our ongoing engagement with carriers within CSTAC, we have posed questions along these lines to better understand their operations. But in terms of their operations, they are dealing with like best in the world companies that are providing mission critical services to large Canadian companies, but also, say, AT&T or Orange in France or that type of thing. And so they are providing best-in-class services to support that.
Yeah, thank you for the question, Mr. Chair. I would add that in the context of maintaining a telecom network, it is in the context of global equipment manufacturers. There are efficiencies to be gained. I'm not suggesting that, that's the reason why jobs are being offshored, but that's a consideration for the telecom companies to decide. What we are interested in the security of the infrastructure. And if they follow the standard, as some members have mentioned earlier, if there are already standards they're following and is strong, we do not have any objection because the objectives of the Telecom Act is being met. So we leave that decision on them. What we're interested in is a collaboration among the telecom service providers with the intel agencies and security agencies to ensure that we have the best protection and reliability of the network in Canada.
And I apologize. One last thing I would add is that should a risk be identified in this type of context, C8 would give the authority to remedy that risk. But there would need to be a clear risk, and we would need to be taking action would be reasonable in relation to that risk.
Okay. Well, yeah, I want to highlight the importance of this question is because when telecom operations or data is handled outside Canada, they are subject to foreign laws and government. And how does the department see this affecting privacy, data protection, and national security risks, especially given the objectives that you guys are bringing forward with Bill C8?
Thank you, Mr. Chair, for the question. So C8 is concerned with the management of telecommunications networks and services and allows for action to manage those instances. In terms of the handling of personal information, there are a set of existing requirements under PIPEDA, but I also know Minister Solomon has plans to improve those, and there'll be more to come in due course on privacy reform.
Okay. Right now, the Telecommunications Act and Policy Direction to CRTC prioritizes competition, affordability, and innovation. Employment in Canada, data sovereignty, and system-wide network security aren't explicit objectives. Does the department see a gap, particularly in Bill C8, trying to improve these telecom securities?
Thank you, Mr. Chair, for the question. So certainly the government's 2023 policy direction does not get into questions of security, in part because it was made pursuant to the Telecommunications Act, and those considerations did not exist in the Telecommunications Act at that time. But that is part of the raison d'etre of adding the protection of the Canadian telecom system to the policy objectives of Section 7 in C8, and to establish a legal framework by which the government can actually take legal action to protect telecommunications infrastructure.
Okay. Has the department...
Sorry, Miguel. Again, I'm being rude because that's all the time we have for this this intervention. Let me thank both of you, Mr. Arbour and Mr. Kwan, for your presence today, for the hard work. Let me also take advantage, which perhaps I'm not supposed to do, from a procedural perspective, to signal that behind you there is a lady, Shauna Camis, who is a student in law at the University of Ottawa, who is working with analysts and one day might be sitting on this side of the room, who knows. So thank you, Ms. Camis, for your early interest in law and in politics. Which, Mr. Ramsey?
Monsieur le Président, juste...
Chair, I'd just like to advise you that parties have had discussions with the Finance Committee with leaders, and I hope there will be unanimous consent for the following motion on C15 pursuant to Standing Order 1082, the committee undertake a study of the subject matter of Bill C15, specifically Clause 371, Division 19, and Clauses 380 to 385, Division 21, that it invite the Minister of Public Safety for 1 hour followed by the National Police Federation for 1 hour to appear for 1 hour by Friday, February 13th, 2026, and that it forward any recommendations or suggested amendments to the Standing Committee on Finance by Thursday, February 26th. Thank you, Mr. Ramsey. As you know, we require unanimous consent to debate the motion. Is there unanimous consent?
Oui.
I see that there is. Madame de Bellefeuille, will the clerk be conveying the information before February 4th, before the Finance Committee meeting? Yes, if the motion is adopted, we have to ensure that the information is transmitted, is conveyed. Any speakers to this motion? So I can assume that it has been adopted. Everyone agrees to adopt it. Adopted. Just take a few seconds to highlight what's coming up. February 29th, we will not be sitting because the schedule has been changed. 3rd, 5th, and 10th February, we have clause by clause on Bill C-8. February 12th, probably, we'll have the follow-up to the motion we just heard. And February 17th, February 19th is constituency week. Chair, could you ask the clerk to get in-person interpretation services for clause by clause? It really would help me follow the clause by clause proceedings. I will do so with a big smile on my face, and I'm sure the clerk will be delighted to